This video is going to have a look at the civil process specifically for contract law. So there are two questions at the end of the contract part of the Law02 exam paper for AQA. They seem a bit wordy, but once you break them down, they're ever so simple. So the first question is on the courts and the tracks. And the sort of question that you might get is outline the procedure which would be followed in any claim for breach of contract arising out of the potential contract between the claimant and the defendant, and that would be 5 marks. The other question would be about damages, and it will be something along the lines of outline the law relating to the calculation of damages in contract and briefly discuss how this law would apply to any claim arising out of a potential contract between the claimant and the defendant. So let's first of all look at the procedure question. This is also known as the courts and tracks, so that might be mentioned in the question as well. So if we look at the civil courts first of all, remember that the burden of proof, the party that has to prove their claim, is the party that brings the claim, so the claimant. And the standard of proof is on the balance of probabilities. So the claimant has to prove that on the balance of probabilities, it's more likely than not that what they are saying is the truth. So how do you decide which court is going to hear the matter? Well, this is based on seriousness. And how do you work out the seriousness in a contract case? Well, it all comes down to money. So we look at how much each matter has lost in order to work out which track the case will be allocated to. So the small claims track is used for matters less than £10,000 or for personal injury claims for less than £1,000. The fast track is for claims between £10,000 and £25,000, which will be completed in a day and don't involve too much complex oral evidence. And the multi-track is for cases which are more complex and a higher value, above £25,000. So to work out which court, this is really simple. If the matter is for less than £50,000 and is quite straightforward, it will be heard at the county court. If the matter is for more than £50,000 or it's very complex, it will be heard at the High Court. So when we're looking at the procedure which is followed with a contract claim, what you need to remember is nothing ever gets sent directly between the claimant and the defendant. The court is always the middleman. Think about it. This is to avoid making things even worse. If the claimant and the defendant can contact each other directly, you think about the sorts of things that they might say to one another. Using the court as a middleman ensures that you don't say or do anything to get yourself into even more trouble. So the procedure to trial. First of all, the claimant completes the claim form, which is Form N1, or via money claim online, and pays the court fee. And this is then sent to the court. The court then sends out the claim form, acknowledgement of service, admission form, and a defence form to the defendant, who has 14 days to reply. They have to send back the acknowledgement of service to show that they've actually received the documents. If they want to just admit it, they would fill in and send back the admission form. And if they choose to defend the matter, then they would send back the defence form. An allocation questionnaire is then sent out to the claimant and the defendant to work out the location, track and timing of the trial, and a fee of around £80 is then charged to the claimant. The defence form is then sent to the claimant, and once all of this documentation has come back, the court can then allocate the matter to either the small claims track, the fast track or the multi-track. If the defendant believes that they are actually the injured party, they can put in a counterclaim. And the rules of how you have to conduct yourself in court are governed by the pre-action protocols. Alternative dispute resolution is set out in the civil procedure rules, and it requires that the parties are under a duty to try and use alternative methods to avoid going to court. And in your exam, you're going to say something like, the parties are encouraged to avoid going to court by using alternative dispute resolution methods such as negotiation or arbitration. So the application that you will use for this question is quite simply, in this case, the case will be allocated to this particular track and heard at this particular court. So the other question that you're going to have to answer is a question about calculating damages. You'll need to discuss how damages are calculated in the law and then apply this to any claim between the claimant and the defendant. So let's look first of all at breach of contract. If there is a breach of contract, then damages are paid when the contract has not been performed properly. And the purpose of these damages is to put the claimant back into the position as if the damage has never occurred, as stated in Robinson and Harmon. Loss of bargain is compensation for something which has been lost. Consequential losses can only be claimed if they are reasonably foreseeable, and there must be a chain of causation between the defendant's breach and the breach of contract. Remoteness of damage is that the defendant cannot be responsible if the consequences are not foreseeable or they're too remote, because the consequences could be never ending. And this is illustrated in the case of Hadley and Baxendale. This case tells us that the defendant is responsible for normal losses, which are things which are naturally occurring consequences from the breach, and also abnormal losses if they are in the contemplation of the parties. The claimant is under a duty to mitigate their losses, which means to keep them down to a minimum. So, for example, if a business suffered a loss, they should do everything they can to resell the product or service. You can claim for emotional distress, which only applies to individuals, as stated in Jarvis and Swan Tours, and businesses can apply for loss of profits. So what you need to do now is go back and have a look at the notes that you've written from this presentation and write yourself a short model answer. Ensure that you can write the answer that you write both on damages and on procedure to trial, so you're going for two different answers in 4 minutes. And then you'll have 1 minute available at the end to apply your knowledge. When you're applying, make sure you refer to the defendant and claimant by name. Come to logical and common sense conclusions and don't overcomplicate things. When you're looking at the damages section, you may be given specific figures to indicate what loss has occurred, and therefore you'll have to do simple mathematics to work out an exact figure. It may be that you're not given any figures and you'll just have to come to a common sense conclusion as to the sort of loss involved. You're not going to be penalised if you're a little bit wrong, but make sure that you're using common sense to work out a sensible figure.